here to address the clarification questions posed on the 6th of September, 2024. Additionally, I would like to inform you that the addendum has been submitted to Parliament for review. This addendum has been agreed upon by the technical team of St. Martin, Curaçao, and the Central Bank. Some may ask why this document has not yet been signed. The reason is that, unlike previous practices, I believe it is important to obtain Parliament's approval before finalizing the document. While the addendum has not been signed, it has been discussed with the Prime Minister, as both he and I will need to sign it. If you compare this with a legislative trajectory, once a legislation is submitted to Parliament, it can be amended up until the point when Parliament votes on the legislation. This amendment can be on the initiative of government through a so-called nota van wijziging, or on the initiative of Parliament. In this case, based on the feedback from Parliament on the outline agreement, I, as Minister of Finance, took the initiative, resulting in the addendum to the outline agreement as presented during the public meeting of Parliament of September 6, 2024. I believe this addendum is feasible, as on a technical level, there is an agreement between St. Martin, Curaçao, and the Central Bank on this addendum. If the Parliament of St. Martin approves the addendum, the government will sign the addendum based on the mandate given by Parliament, which order, in my opinion, is the correct sequence, also taking into consideration the background on how the outline agreement reached Parliament, for our Parliament to function as a rubber stamp, which, in my opinion, does not reflect nor respect the authority of our Parliament. The initial HLA high-level agreement was previously approved by the Council of Ministers, and with this addendum, savings and benefits were brought to St. Martin amounting to 37 million guilders. The specific savings outlined in the addendum are as follows: 5 million guilders saved by not covering the BES and Suriname, 15 million guilders saved by excluding operational expenses, 14 million guilders saved due to a reduction in expenses, resulting in a positive cash balance at the end, 3 million guilders saved in interest by separating the peak facility and limiting its use. This amounts to a total savings of 37 million guilders for St. Martin. The addendum has been approved at a technical level, and it is expected that the ministers of Curaçao are aware of this, just as I was kept informed by the St. Martin technical team. You, as members of Parliament, may ask, since the document is not signed, what is the risk if Curaçao does not sign? The answer is that both St. Martin and Curaçao would be significantly impacted if we fail to reach an agreement on ENIA together. Both of our interest rates would increase, affecting 27,000 policyholders in Curaçao and 3,000 plus policyholders in St. Martin. As the Minister of Finance, I cannot, in good conscience, ask the people of St. Martin to agree to the previously signed HLA without this addendum, which would have us bear the execution costs of ENIA as well as cover BES and Suriname policyholders, whose policies are unrelated to the St. Martin's ENIA office. Additionally, the inclusion of a peak facility in which additional costs could be imposed on St. Martin is unacceptable. Lastly, us as St. Martin not having any benefit when it comes to our prime location, Mullet Bay. Therefore, I am here to request Parliament's approval of the outline agreement inclusive of the addendum. I remain fully committed to acting in the best interest of St. Martin, and that is what I am also asking of the Parliament.
Minister. MP Iran, you have the floor.
You only need one. Addendum, we are ensuring that we don't cover Suriname and the BES Islands. But in the addendum itself, if you look at the footnote, at footnote number 5 and number 8, it already states that Curaçao in the HLA already was covering Suriname. Why? As I mentioned in the previous meeting, that at some point in time, these individuals lived on Curaçao. So imagine if I live on Curaçao, right, and I move to Japan, I'm not entitled to my pension. That's one. Two, I'm going to set up another discussion. And also, it also mentions that in footnote number 8. So I would like some clarity on that. If the addendum brings that, or that was already agreed to in the HLA.
Thank you, MP. Minister?
Madam Chair, to respond to the MP's question, indeed, in the footnotes, it does include for Curaçao, but what it does not include was that St. Martin, too, was paying the costs of both the BES and Suriname. And so that is why it was important for the technical team of both St. Martin, Curaçao, and that of the central bank to ensure that we, St. Martin, do not pay for those from the BES Islands and that of Suriname. And that is why in the addendum, it is clearly stated that we do not pay those costs, only the costs for those of St. Martin.
Okay, thank you, Minister. You may continue.
I want to be clear. I stand by my position that linking the COVID loans to finding a solution for Enya was entirely inappropriate. I will continue to state this fact. However,
Minister, before you continue, I have another MP that would like to make use of her interruption. MP Dweaver.
While we were on the topic, what I wanted to make sure that we got clearly was in the minister mentioned that St. Martin was also responsible for the Suriname portion. That means, was it shared costs then beforehand? Because I didn't get that in the explanation, just to make sure that we finish that point off by deciding, because it's now taken out, giving us a significant saving. So I just want to know if in the old one, that means it was being shared between the two. Thank you very much, Madam Chair Lady, and thank you, Minister.
Madam Chair, to answer the MP's question, yes, it was indeed a shared cost.
Okay, Minister, you may continue.
Allow me to just restart that. I want to be clear. I stand by my position that linking the COVID loans to finding a solution for Enya was entirely inappropriate. I will continue to state this fact. However, last year, October 2023, when the short-term refinancing agreement was signed, these two matters were linked, and as such, St. Martin has since then been committed to finding a solution for Enya or risking higher COVID interest rates. It is still unacceptable that the Netherlands were willing to profit from higher interest rates on pandemic loans that will cost the islands millions to bail out a private entity and continues to disregard the pressing development needs of the islands. At the same time, we are forced to read in the Telegraaf that the Netherlands has just received 1.3 billion euros as a grant from the European Recovery and Resilience Facility to recover from the pandemic, while small island developing states like ours are threatened with higher interest rates on pandemic loans from our own kingdom partner. I must state, however, that the Netherlands agreed to remove the clause preventing discussions on loan forgiveness from the new refinancing agreement following my request. Hopefully, there might still be some hope for us with regard to these pandemic loans.
Are you Asset V insured? Do you have a valid medical insurance status? Asset V is cardless. Request your My Asset V account today and enter the virtual office of Asset V. Go to assetv.sx and sign up now.
Asset V, yeah. Your social and health insurances.
It's hurricane season. Are you prepared? Here are a few tips to remember to help keep you and your family safe. If you're not in an area that is advised to evacuate and you decide to stay in your home, plan for adequate supplies in case you lose power and water for several days and you're not able to leave due to flooding or blocked roads. This hurricane season, make a family emergency communication plan. This public service announcement was brought to you by the government of St. Martin.
Lastly, I am deeply disappointed in the central bank's lack of proper supervision over Enya, which contributed to this situation. Their failure to maintain independence during the negotiations of this agreement is equally troubling. It is unacceptable that St. Martin was being asked to shoulder costs for Suriname policyholders, best policyholders, or execution expenses, while knowing that Curaçao and St. Martin will not benefit equally from the continuation of Enya. This should have never been allowed, but thankfully, reading thoroughly with comprehension intercepted these hidden fees which were purposely placed on St. Martin. There are still numerous questions regarding whether the central bank, since taking over the supervision of Enya in 2018, has made the best decisions for the entity. This is a serious issue that must be addressed in due course, as their decisions has and will continue to have a direct impact on the financial obligations of the countries involved. Therefore, it is crucial that the central bank itself is properly monitored by the countries on this matter moving forward, and I intend to continue to question them on this matter. I will now continue with the answers to the clarifications. MP Sarah Westcott Williams. Madam Chair, through you. The Minister, throughout her answers and introduction, has mentioned the issue of time constraint and the complexity of the issue at hand. And so I would like to know if there is anywhere in the document, the HLA and or the addendum, that mention is made of the possibility for St. Martin, both countries, Curaçao and St. Martin, to challenge any legalities that could further jeopardize the financial economic position of St. Martin, for example, for a period of 2 years. Is there any way that we can seek to guarantee that if something comes up in the next 2 years that jeopardize the position of St. Martin, that it can be inserted? The answer from the central bank, it is not clear to which legalities this question relates, but pursuant to Article 7.4 of the outline agreement, the parties will review the duration of the continuing capital contribution 15 years after the implementation date and consult in good faith if necessary for necessary changes. Can we safeguard St. Martin from any liabilities litigation that could arise from this three-party agreement? Answer from the central bank.
Minister, before you answer, I have MP Westcott Williams that would like to make use of her interruption.
Thank you, Madam Chair Lady, and a good morning to all, to the Minister and her support staff. Madam Chair Lady, through you, I would like to respond to what I understood was the question or the comment from the Central Bank of Curaçao and St. Martin regarding an answer given to my question. What kind of legalities? My question had to do with the fact that if in the headline agreement and or the addendum, the possibility for St. Martin to be safeguarded against any potential legalities, any legalities, other third parties challenging these agreements in which St. Martin is party. So let me make it clear, that's what I want to clarify. Those kind of legalities, I can't pinpoint this person will come with that legal matter against St. Martin, Curaçao, and the Central Bank, any legalities. This matter has been also, from the words of the Minister, under pressure, time pressure and otherwise. Do we have the possibility for a year or such to challenge the agreement, one, and to be protected against any challenges coming from third parties to the agreement? Thank you, Madam Chair Lady.
Yes, Minister, you could answer that clarification
So MP Westcott's additional question was, can we safeguard St. Martin from any liabilities litigation that could arise from this three-party agreement? And the answer provided again by the central bank, the risk of the countries being held liable by third parties for their role in the resolution of ENIA seems limited, as the countries are involved only as financiers and at a distance, and the implementation of the resolution is mainly done by the central bank. Following question from MP Westcott. Based on the HLA, can Parliament obtain an organizational breakdown of the management structure or organogram of ENIA? Answer, corporate structure received and submitted confidentially to Parliament. Clarifications. When will the agreements and the obligation be reflected in the budget of the country? Based on the outline agreement and the addendum, the payments will commence in 2027 and will therefore be reflected in the 2027 budget. However, regarding the refinancing agreement, the approval of this addendum will directly impact both the amended 2024 budget and the 2025 budget by reducing our interest expenses. Consequently, a nota van wijziging amendment note will be made to reallocate the savings in interest to another budget line in the 2024 budget. Regarding profit and dividends to be paid by central bank, and stated that the last time dividends were paid in 2022, was this of 2022 or in 2022? MP Westcott asked this question because previous information indicated that the last time St. Martin received payment from the central bank was in 2019. So did we also receive payment in 2022, or was this in fact a payment from a prior year paid in 2022? The answer, dividends from central bank to St. Martin and Curacao are calculated on a yearly basis depending on the financial results of the central bank. In 2021, the financial results did not give rise to dividend payments. In 2022, the net profit of the central bank was approximately 1.3 million guilders, of which approximately 290,000 guilders is attributed to St. Martin, as included in the 2022 audited central bank financial statements. 3, concerning confidentiality, how will the central bank as regulator seek to comply with the confidentiality rules of an enterprise that is receiving public funds? What can the Parliament ask for or not based on this? Based on the HLA, can Parliament obtain an organizational breakdown of the management structure or organogram of ENIA? Answer, the attached corporate chart has been confidentially submitted to Parliament. With the new structure, ENIA New will be transparently organized and ownership will be brought under the management foundation until ENIA New can be responsibly brought into private hands. ENIA New will be subject to supervision by the central bank. The different roles are kept strictly separate. All funding runs through the resolution fund, and the resolution fund has no control in relation to ENIA New due to a certification structure that will be put in place. ENIA New will receive a one-off capital injection against the issue of share certificates. Therefore, ENIA New cannot rely on funding from public funds. Question 4, would like to receive the loan refinancing agreement made last year between the Netherlands and St. Martin. Answer, refinancing agreement was sent confidentially to Parliament. What is meant, question 5, with St. Martin having received the first right to purchase Mullet Bay? Specifically, what does this entail? Answer, in order to strengthen St. Martin's ability to purchase Mullet Bay at a market valuation and determine its future while still delivering maximum proceeds to the creditors of ENIA, St. Martin will be granted a matching right in a Mullet Bay sales process. In brief, this matching right entails the following. If pursuant to the sales process, St. Martin makes a binding offer for Mullet Bay, but is not considered to be the winning bidder, then St. Martin shall have an opportunity to improve its offer and match the winning bid. This entails that once a bid is made for Mullet Bay and St. Martin submits a bid in the event that there is a higher bid, St. Martin will have first priority to purchase at the higher bid. Question 6. Are we to receive a redrafted HLA that will include the addendum, or will the addendum be submitted separately? So, will we receive a new agreement that will include the addendum or the old agreement with the addendum agreement as two separate documents? Answer: the old agreement will remain valid, and there will be an additional document to this agreement, which will be the addendum to be signed off by Curacao, St. Martin, and the Central Bank. After it has been approved by the parties, the amendment will be attached to the outline agreement. The outline agreement will remain in force insofar as the addendum does not amend it. Question 7. Have mentioned pre- and post-emergency liabilities based on the regulations. Can a further outline be provided? Answer from the Central Bank: the distinction between pre- and post-emergency regulation obligations depend on whether an obligation has accrued on the date the emergency regulation became effective on ENIA, dated July 4th, 2018. Post-emergency regulation liabilities include: 1, all rights and liabilities of former ECL arising from new policies effective as of July 4, 2018, and 2, rights and liabilities of former ECL accrued as of July 4, 2018, and accrued from policies effected before the 4th of July, 2018, whether or not the policies in question were subsequently renewed, including premiums paid as of 4th of July, 2018, and the returns accrued thereon.
Your social and health insurance is your social and health insurance.
Are you SHV insured? Do you have a valid medical insurance status? SHV is cardless. Request your My SHV account today and enter the virtual office of SHV. Go to shv.sx and sign up now.
Your social and health insurance.
Pre-emergency regulation liabilities include the rights and liabilities of former ECL arising prior to the emergency regulation. All rights and liabilities of former ECL, including the return on premiums paid before the 4th of July, 2018, other than post-emergency regulation liabilities. Question 8. Referring to the review after 15 years based on Article 7.4, in answer to my question regarding an escape clause, does this agreement require that the monetary union remain intact for the duration of the agreement? Answer from the Central Bank: the outline agreement is not dependent on the monetary union between Curacao and St. Martin remaining intact. Question 9. Regarding the motion passed by Parliament of Curacao on promoting the sale of Enya New, is Central Bank pursuing this motion and actively pursuing the sale of Mullet Bay? Answer: the managing board of Sun Resorts is working on the best scenario for Mullet Bay in the interest of all stakeholders, including the policyholders of Enya. Central Bank, in its role under the emergency regulation, will continue to evaluate the best way forward for Mullet Bay in light of the goal of the resolution, which is to reach the best outcome for all creditors of ENIA, including its policyholders. Question 10, getting back on Mullet Bay, based on what plan has the central bank offered a part of Mullet Bay for sale? Does the plan on what the central bank is offering Mullet Bay or parts thereof for sale include the beach, and to what extent? Answer, the part of Mullet Bay that currently has been offered for sale is not located next to the beach. Question 11, the central bank on behalf of Sun Resorts had asked about a building permit that was given. Was the building permit on or off the beach? Answer provided, the location of contested building permit was next to the beach. Minister referenced 230 million guilders as the verdict for the courts of appeal. Is that the sum thus far? Answer, the Joint Court of Justice of Aruba, Curacao, St. Martin, and of Bonaire, St. Eustatius, and Saba recently confirmed in an interim judgment liability for an amount of at least 230 million guilders, and the recovery proceedings are still pending. In that same judgment, the court appointed an expert to further investigate the historical value of Mullet Bay in order to rule on substantial claims relating to, amongst others, dividend payments based on an excessive value on Mullet Bay. It is noted that this is only an interlocutory judgment, and it is expected that a higher amount of damages will be awarded in the final judgment. Question 12. Minister indicated that a cash flow overview is presented to Parliament confidentially. Has it already been submitted, or is it that it will be presented to Parliament? Answer, the cash flow attached to the initial outline agreement was shared with Parliament confidentially on July 18, 2024. The updated cash flow overview comparing the initial agreement to the addendum was also sent to Parliament confidentially alongside the addendum. And finally, question 13, why is the agreement for the refinancing of the COVID loans confidential? The agreement has been shared with Parliament confidentially in accordance with the National Ordinance on Public Access to Government Information. I move on to questions by former MP Jacobs. Related to time to find a new solution, I understood that the minister stated that the central bank misled the government of St. Martin with the calculations that has been made. Please confirm that this is what was said and clarify in what way was the government misled by the Central Bank of St. Martin. My answer, Madam Chair, I did not state that the central bank misled the government. What I did state, and in my opinion remains, is that the initial signed outline agreement was not in the best interest of St. Martin. It is important to emphasize that it is the responsibility of the countries to ask all necessary questions, receive clear answers, and fully understand the financial implications to ensure that they are aware of what they are committing the country to. This is not a simple agreement, which is why I took the time to thoroughly understand it. By continuously asking questions and receiving answers, it became evident that St. Martin was paying for way more than just its own policyholders.